Their patents suck. The Problem of Patent Trolls, Part 3. I'm Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. As I mentioned in Part 2, I don't have a problem with the business model of trolls per se, but there are some significant holes in the patent system that they exploit to their great advantage. The first is that the law is not very well defined in terms of how broadly you can claim an invention relative to the embodiments you disclosed. I am not talking about how broadly you can claim relative to the prior art. That is a well-developed body of law. I'm talking about how broadly you can claim an invention relative to what you've actually taught in the patent application. In the troll cases I've been involved in, the claims were broad enough to potentially read on things that the defendants were doing, but they went way beyond anything that was possibly in the contemplation of the inventors at the time that the patent applications were filed. And that seemed to the defendants to be grossly unfair. I think it seems that way to many people. And the problem is that the law has two doctrines in tension. One doctrine is that you are allowed to claim an invention more broadly than your embodiments. There's dozens of cases that say the claims are not to be limited to the preferred embodiments. However, there's also another body of law that's not very well developed, in my view, that says if you claim too broadly, such that the claims read on non-enabled embodiments or embodiments that a person skilled in the art would not think were in the possession of the inventor at the time the application was filed, then the claims are invalid under the enablement and or written description requirements. One of the problems with that is that's not something the Patent Office is in a position to evaluate, if for no other reason, because we're talking about situations where the claims are being read upon things that don't exist, and the examiners can't really guess what that might be and what problems that might cause. And the patents that are of value to a troll are exactly those kinds of patents. And I think it's because those kinds of patents show up in troll cases that so many people have been upset about them. I mean, in one case I was involved in, the patent had to do with filming an area and associating coordinates with the area and then replaying specific videos that correspond to the area when you kind of go back and look at a content image. So it's like a spatial content image where you could replay video corresponding to locations in space, right? Well, they read the claims on Blu-ray content menus with the thumbnails showing different parts of the video that were mandated by the Blu-ray standard, which seemed very different to the defendants in the case and seemed grossly unfair to a lot of people. And so that's just one example. Anyway, that's one example of what happens in these troll cases. I'm going to give you another one in the video tomorrow. I hope it helps keep you out of trouble, and I hope to see you here soon.